In less than 24 days, 10 sweeping federal and state firearms law changes detonate, capable of transforming your lawful concealed carry into a hardened felony overnight. I'm demanding your attention now. January 1st, 2026 is merely 3 weeks out. 4 of these are already active legal traps, and the 10th involves a pending federal proposal that could effectively double the crippling cost of your essential ammunition. If you exercise your concealed carry right or possess any firearms, at minimum, 3 of these legal maneuvers will directly compromise your personal liberty and financial solvency. You must subscribe to this channel immediately. Firearm statutes are weaponized and changing every single week, and missing just one crucial update could irrevocably cost you your freedom. Law 1. ATF Pistol Brace Rule. Final enforcement. On January 1st, 2026, the ATF Pistol Brace Rule slams into its final, catastrophic enforcement deadline. This mandate impacts over 40 million stabilizing pistol braces currently held by responsible American gun owners. If your home defense AR pistol or vehicle carry AK pistol currently utilizes a stabilizing brace, you must internalize this now. You have exactly 24 days remaining to cure this severe legal vulnerability. The previous registration amnesty period evaporated back in May 2025, which means the free registration of your braced pistol as a short-barreled rifle, SBR, is no longer an option. The pivot point on January 1st is the commencement of active criminal enforcement by the ATF. Federal felony charges will be levied with 0 warnings. If you successfully navigated and completed registration during the amnesty window by filing ATF Form 1 and securing approval, you are legally secured and require no further action. However, if you retain a pistol with an attached brace and failed to register it, failed to remove the brace, or failed to legally modify the weapon to exceed 26 inches in overall length, you are in current illegal possession of what the ATF officially classifies as an unregistered short-barreled rifle. Post-January 1st, mere possession of that firearm becomes a federal felony, punishable by up to 10 years in federal prison and a $250,000 fine. Law 2. Illinois Magazine Capacity Criminal Enforcement. This devastating statute already activated on November 15, 2025, just 23 days ago, and a dangerous majority of gun owners in Illinois remain unaware of this new legal exposure. Illinois passed the Protect Illinois Communities Act in January 2023, which legislated a ban on the sale of magazines exceeding 10 rounds for handguns and 15 rounds for rifles. Crucially, existing owners were initially permitted to retain their magazines via a grandfather clause. That legal firewall was torched on November 15th, when Illinois escalated enforcement from civil infractions to criminal prosecution. Now, possession of these standard capacity magazines is a Class 3 felony, carrying a direct sentence of 2 to 5 years in state prison. Let me establish the critical threat this represents. If you possess a standard-issue Glock 17 magazine designed to hold 17 rounds, and you reside in Illinois, if law enforcement discovers that magazine in your residence, your vehicle, or any other location, you are facing felony charges. This is true even if the magazine is entirely unloaded and empty. The Illinois State Police are now aggressively conducting traffic stops, and upon running your license and confirming a firearm owner's identification, FOID card, they are directly inquiring about your magazines. In the first 7 days following November 15th, the Illinois State Police seized over 1,200 magazines and effectuated 47 arrests. Prosecutors are under direct mandate to use early violators as intentional legal examples. Law 3. Montana Constitutional Carry. Full expansion. Montana is expanding its constitutional carry mandate to encompass all firearms categories on February 1, 2026. This represents one of the most powerful pro-Second Amendment expansions being ratified this year. Constitutional carry establishes the right to carry a concealed firearm without any government permit, without any mandatory training requirement, and without any registration requirement, provided you are not otherwise legally prohibited from possessing a weapon. Montana already enshrined constitutional carry for handguns. But effective February 1st, this legal protection extends to both rifles and shotguns, critically including the transportation of loaded long guns within your vehicle. The simple, empowering reality is this. If you are 18 years of age or older and legally eligible to possess firearms, you can lawfully carry a concealed handgun, rifle, or shotgun anywhere in Montana without any bureaucratic paperwork starting February 1st. If you are a visitor traversing Montana for hunting, hiking, camping, or simply passing through, you can carry concealed the instant you cross the state border, with no Montana permit required. Montana retains an optional concealed weapons permit, and you should consider securing it, as that permit grants you essential reciprocity with over 30 other states. Law 4. California Private Property. Carry Ban. California is implementing one of the nation's most restrictive and legally perilous private property carry statutes on March 15, 2026. This legal landmine directly affects every single California CCW permit holder. Assembly Bill 2571 was signed into law in September 2025, and it empowers any private property owner, business operator, or landlord to designate their premises as a rigid, gun-free zone, enforceable with both civil liability and criminal penalties for any violation. Starting March 15th, if a business explicitly posts signage stating "No firearms allowed," with the required specific reference to California Penal Code Section 26230, your entry onto that property while carrying a concealed firearm immediately becomes criminal trespass, even if you possess a currently valid CCW permit. The stark real-life implications are severe. Grocery stores, gas stations, shopping malls, restaurants, movie theaters, and even their parking facilities can legally outlaw concealed carry by simply posting the required official signage at their entry points. If you enter a properly signed property while carrying concealed, the first offense is a misdemeanor, carrying up to 6 months in county jail, a substantial fine, and the automatic mandatory suspension of your CCW permit for 1 full year. If you are a California CCW holder, starting March 15th, you must meticulously examine the entrance of every building you seek to enter, because missing one of these legally mandated signs could permanently cost you your permit and freedom. Law 5. Texas and Pennsylvania Reciprocity Agreement. Texas and Pennsylvania have finalized a critical concealed carry reciprocity agreement set to take effect on January 15, 2026. This is a major legal victory for millions of responsible gun owners in both states. Currently, Texas refuses to recognize Pennsylvania's license to carry firearms, LTCF, and Pennsylvania similarly refuses to recognize Texas license to carry, LTC permits, which has engineered dangerous legal problems for citizens traveling between these critical jurisdictions. Effective January 15th, if you possess a valid Texas LTC, you can legally carry concealed anywhere in Pennsylvania where carry is permitted. Reciprocally, if you hold a valid Pennsylvania LTCF, you can legally carry concealed anywhere in Texas where carry is lawful. This agreement is fundamentally significant. Pennsylvania is an essential travel corridor for anyone moving between the East Coast and the Midwest, and Texas is the nation's second largest state, housing over 1.8 million active license to carry holders. Before this agreement, Texas residents driving through Pennsylvania were forced to either abandon their firearms at home, secure them unloaded and locked within their vehicle, or face the risk of felony charges. Understand this constraint. You are still required to adhere to the host state statutes regarding prohibited carry locations, and those specific laws do differ between the two states. Law 6. Federal Background Check System Modernization. The FBI launched a completely modernized National Instant Criminal Background Check System, NICS, on October 1, 2025, and it is actively inducing massive, unacceptable purchase delays at gun stores across the entire nation. This statutory change already took effect over 2 months ago, but the majority of gun owners fail to comprehend the legal changes or why their background checks are being subjected to such unreasonable processing times. The FBI systematically upgraded NICS to integrate mental health records, domestic violence records from all 50 states, misdemeanor criminal convictions, juvenile records in specific states, and state-level restraining orders into one vast, unified, and slow database. Prior to October 1st, when you submitted Form 4473 at a licensed dealer and the dealer initiated your background check. The system queried 7 distinct databases, usually finalizing the check within 2 to 10 minutes. The new upgraded NEX now aggressively searches 18 different databases, including specific state mental health commitments, protection from abuse orders, and misdemeanor domestic violence charges that were previously not flagged for review. Background checks are now consuming anywhere from 30 minutes to a full 48 hours, and a dramatically increased percentage are being returned as delayed, which means the dealer is legally prohibited from transferring the firearm until the delay is officially resolved. If you plan to acquire a new firearm, you must now bring multiple forms of identification: your driver's license, your concealed carry permit, if held, and any court-certified documents showing the final outcome of any past charges, if applicable. Law 7. Michigan Pistol Purchase. Permit elimination. Michigan is completely eliminating its archaic pistol purchase permit system on July 1, 2026, a system that has served as a bureaucratic barrier since 1927. Currently, if you intend to purchase a pistol in Michigan, whether from a licensed dealer or a private seller, you are mandated to first secure a license to purchase from your local police or sheriff's department. Starting July 1st, that entire antiquated system vanishes, and Michigan will operate like most other states, utilizing the federal NICS background check at the actual point of sale. House Bill 4138 was codified in August 2025, and it eliminates the purchase permit requirement for both dealer and private transactions. However, it imposes a new, critical requirement. Private sales must either be processed through a licensed dealer who conducts the NICS check, or both the buyer and seller must strictly utilize Michigan's official online verification system. If you are purchasing a pistol from a gun store, effective July 1st, you simply complete the required Form 4473 and proceed through NICS as you would in any other state, with no additional Michigan permit required. This is a massive victory for Michigan gun owners, as the purchase permit system was notoriously slow, bureaucratically inefficient, and an expensive tax, with certain jurisdictions unjustly charging $50 or more per permit, and forcing citizens to endure weeks of agonizing wait times, even for simple legal purchases. Law 8. Washington State Ammunition Background Check Requirement. Washington State is implementing mandatory point-of-sale background checks for every single ammunition purchase, starting April 1, 2026. This represents one of the most restrictive and punitive ammunition statutes to be weaponized in the entire country. Here is the precise financial nightmare it unleashes. Starting April 1st, every single time you acquire ammunition in Washington State, whether a single box or a bulk order, the dealer is legally compelled to conduct a background check via the Washington State Patrol before they are legally permitted to finalize the sale. This background check incurs a non-negotiable $18 fee per transaction, not per box. Therefore, if you acquire 5 boxes of ammunition in one single transaction, you are taxed $18 one time. But if you return the following day and purchase one additional box, that purchase triggers another $18 tax. This mandatory fee is levied on top of the core cost of your ammunition. If you are purchasing a 25 box of 9mm, your actual final cost at the register will be $43. For citizens who shoot regularly at the range or train frequently, this regulatory tax becomes catastrophically expensive with alarming speed, because every single purchase triggers that oppressive $18 fee. If you visit the range weekly and acquire ammunition on each visit, you are effectively paying $936 annually solely in background check fees, before you even account for the actual ammunition cost. If you reside in Washington and are a regular shooter, you are compelled to begin acquiring ammunition in extreme bulk before April 1st to successfully circumvent paying that relentless $18 fee dozens of times throughout the year. Law 9. Federal Forced Reset Trigger Ban. On January 1, 2026, forced reset triggers, FRTs, will be federally reclassified as machine guns under the Severe National Firearms Act, NFA, and mere possession will immediately become a federal felony with no available registration option. The ATF issued a final rule in August 2025 that explicitly reclassifies forced reset triggers, including widely sold devices like the rare breed FRT-15 and wide-open triggers, as illegal machine gun conversion devices. This is a critical distinction from standard binary triggers, which remain currently legal because binary triggers require the user to actively pull the trigger once for the first shot, and then actively release the trigger for the second shot. Starting January 1st, if you possess any forced reset trigger device, possession is a federal felony punishable by up to 10 years in federal prison and a $250,000 fine. And unlike the pistol brace rule, there is no registration amnesty being offered. You have 3 legally defined options before January 1st. Surrender the device to the ATF using their voluntary surrender program, incurring 0 penalties. Destroy it strictly according to the official ATF destruction guidelines and retain verifiable photographic evidence of the destruction. Sell it to a Class 3 SOT manufacturer who is legally licensed to possess machine guns. The ATF maintains manufacturer sales records and dealer distribution records, meaning they have a verifiable, strong estimate of who initially purchased these illegal devices. Law 10. Federal Ammunition. Excise Tax Increase Proposal. Here is the 10th impending crisis, the one most gun owners remain completely oblivious to. Congress introduced the Firearm Excise Tax Modernization Act of 2025 in November. Should this bill successfully pass into law in 2026, it would violently increase the federal excise tax on all ammunition by a crippling 500%, an absolute certainty to double or triple the current cost of your ammunition. Currently, ammunition manufacturers are mandated to pay an 11% federal excise tax on pistol and revolver ammunition and a 10% tax on rifle and shotgun ammunition. The proposed legislation would unilaterally raise that tax to 50% on all ammunition across the board. The severe implication is that a standard box of 9mm ammunition that costs $20 today would cost an estimated $35 to $40 after this destructive tax increase is implemented. The bill currently boasts 67 co-sponsors in the House of Representatives, a level of support far greater than most gun owners realize. It currently sits waiting for a vote in the pivotal House Ways and Means Committee. If you are a citizen who shoots regularly for essential practice, competition, or training, and you acquire 1,000 rounds annually, this tax proposal would legally mandate an additional $500 to $800 annual cost, levied solely in federal taxes. You must contact your congressional representative and both of your senators immediately and explicitly demand their opposition to the Firearm Excise Tax Modernization Act. Should this bill begin to move aggressively through committee hearings, you must strategically consider acquiring ammunition in massive bulk before this oppressive tax takes effect. These are the 10 critical firearms law changes detonating in 2026 that every concealed carry holder is mandated to know about right now. If you possess a pistol brace or a forced reset trigger, you have less than 24 days to initiate decisive action before you commit a hard federal felony. If you reside in Illinois, California, or Washington, you must take immediate action to maintain your legal status. Firearms laws are being weaponized and enacted faster in 2025 and 2026 than they have in decades. The only reliable shield protecting you from devastating felony charges is maintaining constant weekly information. You must subscribe to this channel immediately and activate all notifications, because I am covering every new firearms law change the instant it happens, complete with the specific deadlines and the critical action steps you are required to take.